Hi, I would like to welcome and thank everyone for joining today's Meritas Capability webinar entitled Major Revisions to U.S. Export Controls, How the New Regulatory Landscape Will Impact Your Clients. My name is Crystal Dahl, and I am the Online Communications Specialist for Meritas. Today's webinar will be presented by Meritas members Carrie Scarlett and Ian Moss. Both Carrie and Ian come from the firm Goulston Storrs in Boston, Massachusetts. Carrie's practice focuses on business and international trade law. He assists clients in entering or expanding their presence in international markets and provides counsels regarding import, export, regulatory compliance, foreign sales and distribution of products, overseas manufacturing sourcing, establishing strategic alliances, joint ventures, and acquiring selling businesses. Carrie represents clients in reviews before the CFIUS, as well as on matters relating to the FCPA. Ian counsels clients on the appropriate jurisdiction and classifications of products and technologies, applicable export-import licensing requirements, as well as the availability and use of license exemptions and exceptions. Ian's expertise extends to the OFAC regulations, embargoes, FCPA, special sanction programs, and U.S. customs regulations. He also represents clients in reviews before CFIUS and other agencies regulating international trade. Prior to his legal career, he managed hydrographic survey operations for clients in the Middle East. Now, before we get started, I would like to go over a few housekeeping items. As many of you have likely noticed, all telephone lines have been muted. If you have a question for any one of the presenters, you are welcome to ask via the chat feature found on the left-hand side of your screen. We are planning to answer your questions at the end of the presentation. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. With that, Ian, are you ready to get started?
Yes, I am.
Wonderful.
Thank you, Crystal. Can you hand it over to me?
Yeah, go ahead.
Great. Thank you very much. So thank you, Crystal. Thank you for that introduction, and thank you to Meritas for letting us host this program. And obviously, most of all, thank you to all of you for attending and taking an hour out of your time to listen to this webinar. Over the next hour, Kerry and I are going to touch on U.S. export control rules and regulations, how they affect businesses both in the U.S. and abroad. And particularly, we're going to spend a bit of time focusing on recent export control reforms that have been going on here in the United States and the impact that those have on people, in your businesses or for your clients, to the extent that there are law firms listening in, and how those regulations and particularly the reforms can affect you both in the negative and in the positive. We'll also touch on some of the extraterritorial reach of these regulations, how these regulations expand beyond the shores of the U.S. And affect businesses and recipients of U.S. goods overseas as well. And then finally, Kerry will touch on some other trade-related matters as they relate to international trade, both coming into the United States and also going out. To the extent that we see any questions that are relevant to a slide that we're speaking about, we'll try and address it at that time. If not, we will address them at the end. And if we don't, we will make sure that we get back to you via email with an answer. And the same way, please, to the extent that you have questions after this program, both Kerry's and my contact information will be at the end, so please don't hesitate to reach out and give us a call or an email, and we'll try and answer them. Before we start, I thought it would be interesting just to try and get an idea of where people are in their export control journey. So if you could just kind of click on one of these radio buttons and we'll have a bit of a quick poll as to where everybody is in relation to their knowledge here. All right, the results, it's like watching the elections here. So we've got a good mix. We've got a good mix of both very frequent, surprising number of people that are very frequently involved in U.S. export controls, and then a good mix throughout. So interesting. Well, we'll try and tailor a little bit to the audience based on that. So thank you for that. So before we really get into export control reforms, and for some of you, based on this slide, it's going to be old knowledge, but for those that have got little experience or no experience, I think it's worthwhile just touching on some of the, try and move on to the slides, try and touch on some of the U.S. export controls as they exist at the moment, just to give you an overview. So why do they matter? Well, they matter because U.S. export controls probably are some of the most, if not the most, complex export control regulations out there. They're certainly more complex than the EU. A number of countries have single export control regimes, whereas here in the U.S. there are two. So they're complex, so it matters to understand what is the jurisdiction of your product. It's also very important to understand the jurisdiction and classification of your products because everything stems from that. Whether you need a license to export that product, whether you need to have a license to share that technology with a foreign person, whether here in the United States or abroad, all of that arises from the jurisdiction and the classification, so it's very important. It's also important because these regulations have some real teeth to them, and they come with significant penalties and significant consequences for violations, and they are both strict liability statutes. An example very quickly on that is the Aeroflex. There was a case fairly recently involving a company called Aeroflex, which had wrongly classified some of its products in the lowest level. They classified them as EAR 99, meaning that they didn't need a license. Now, other people here in the U.S. relied on that classification here in the U.S., not overseas, and then began exporting those items overseas. And as a result of that, Aeroflex, because of that error, were hit with a significant fine and ended up settling for $8 million in penalties. So there are some real teeth, and those numbers are not unusual. They do carry significant penalties. And with export control reform, the U.S. government has been pretty clear, and they haven't really equivocated. Export control reform is bringing with it increased enforcement. So this is only going to get more significant as time goes on and these rules become finalized. And then finally, obviously, in addition to the government, your customers are watching you, and also your competitors are watching you. To the extent that your competitors are having to jump through these loopholes, if you're not complying, if your company or your client's not complying, then there's a good chance that that competitor is going to drop the dime. So these regulations really do matter. So for all intents and purposes, here in the United States, there are two export control regimes. There are some other agencies that are involved in exports. The USPT Office for Patents, the Department of Energy has some export control regimes, as well as the Nuclear Regulatory Commission. But by and large, 99.9% of the time, a product here in the U.S. or a product overseas where U.S. jurisdiction has still attached is going to be subject to one of two export control regimes. The first one, and probably the easier one, is the International Traffic in Arms Regulations, the ITAR. And the ITAR basically controls defense articles, technical data, and defense services. In essence, it's controlling products that have been built for a military application, for a space-based application, or a product that has significant military intelligence or intelligence aspects to it. That's administered by the Directorate of Defense Trade Controls, which is within the Department of State. If a product or its related technology is not controlled under the ITAR, then it's going to be controlled under the Export Administration Regulations, or the EAR as people often refer to it. That is administered by the Department of Commerce as opposed to the Department of State for the ITAR. And the agency within that is the Bureau of Industry and Security, or BIS as it's known. And the EAR basically controls everything else. It controls commercial products, what we often refer to as dual use. Arguably, dual use is a bit of a misnomer, but dual use products. And then more recently, and we'll address this in detail, it controls less sensitive items that as a result of export control reform have moved out of the ITAR and now are under the EAR in what is called the 600 series. And you'll hear a lot about the 600 series both here in this presentation and obviously going forward, because the 600 series is really entering export control lexicon now. And then over and above both of those is the U.S. embargoes and sanction programs, which is administered by the Office of Foreign Asset Controls, or OFAC. We could talk about OFAC for days, and we're just going to touch on them today, but just bear in mind that in addition to the ITAR and the EAR, OFAC also controls any product or any services that are subject to those regulations. And that's administered by the Office of Foreign Asset Controls within the Department of Treasury. So what is an export? Well, logically, we know what an export is, putting the widget in the box and giving the box to FedEx and sending it overseas. But export is defined much more broadly in U.S. export control regimes. And it's important to understand that. It includes, obviously, technical data and software that is disclosed and transmitted or transferred overseas. But also it includes this concept that is unique to the U.S., this concept of deemed exports. And what that means basically is you can have a deemed export if you're disclosing control technology or you're releasing source code or software to a foreign national, even if that foreign national is an employee or even if that foreign national is here in the United States. That release can be deemed an export to that person's home country if they're not a U.S. person. And a U.S. person is basically anybody who is a citizen or a green card holder. So you can have this concept of deemed export, so a very, very broad definition of exports. And then under the ITAR, we also have this concept of defense services, providing a service to a foreign person. And we'll talk more about that in a minute, but providing a service to a foreign person overseas can be deemed as a defense service, and that is something that is also controlled under the ITAR. So export, very broadly defined, and that's important to know. So the ITAR, what is an ITAR? What's covered under the ITAR? Well, defense articles, and a defense article is anything that's listed on the United States munitions list. And we'll talk more about that in a few minutes, in particular in response to export control reform. But if your item or your technical data is listed on the United States munitions list, or it has the equivalent performance of an item on the United States munitions list, then it's going to be considered a defense article. So that's what a defense article is now, and we'll talk more about how that definition has changed as a result of export control reform in a few minutes. And then there's a catch-all that basically covers future defense articles and services, and basically an article or service will be designated as a defense article or a defense service in the future if it has a critical military or intelligence advantage, such that it warrants control. Don't want to get into that in too much detail. But in addition to the actual defense article, also controlled technical data and defense services. There are a lot of words on these pages, but basically the takeaway here is technical data under the ITAR is anything that gives you information about any how-to information, how to fix a defense article, how to operate it, how to repair it, manufacture it, produce it, any how-to information rather than basic marketing or performance information, how it works. Once you get into technical information about how it works, how it achieves what it's doing, you're going beyond marketing and you're getting into this technical data. So very, very broadly defined definition of technical data under the ITAR. In contrast to the EAR, which controls technology, which is much more narrowly defined, typically limited to either development, production, or use technology. And I don't want to get into that in too much detail. The takeaway from that is that technical data is very broadly defined under the ITAR. And then defense services, we talked about that briefly, but if you're providing a service to a foreign person, manufacturing of a defense article or some form of defense application, you're providing a defense service. If that U.S. person is assisting a foreign person overseas or here in the U.S., then you're providing a defense service which is controlled under the ITAR. Even if that defense service is a collaboration between the U.S. entity and the foreign person for eventual use here in the US, that is still considered to be a defense service, and that has important consequences. Requires something called a technical assistance agreement or a manufacturing license agreement in most instances. In contrast to the ITAR, the EAR covers commercial and dual-use items, as we mentioned, all these items, these less sensitive items that have moved across from the ITAR to the EAR as a result of export control reform, as well as items that are on the multilateral regimes under the Wassenaar arrangements list. It controls equipment, commodities, which is equipment, systems, components, parts, accessories. It also controls materials, software, technology. And we'll talk more about that when we look at the actual commerce control list in a minute and the groups within that. The licensing analysis, in contrast to the ITAR, which is pretty black and white, the licensing analysis, as we'll see, is pretty complicated under the export administration regulations. It depends on the reasons for control, where the item is going, and what the end use is. But with that complexity comes flexibility and a lot more ability to use license exceptions. And I think this slide is telling of the complexity of the EAR. This really gives an overview of the EAR. You can see on the extreme left, that is the commerce control list categories. There are 10 categories. And then within each of those 10 categories, there are subgroups or groups, A being the systems and equipment, B being production and test equipment, C being materials, and then D and E being software and technology. So you have to know whether your product is in the commerce control list. You have to know the product. And as a result of that, as you'll see in a minute, you end up with something called an export control classification number. And then you have to go to the next stage of determining whether your item is then subject to a license, depending on the commerce country chart that you see on the extreme right. And even if none of that applies, and your item is what's called EAR 99, in other words, it's not on the commerce control list, you still have to consider the general prohibitions under the EAR. So it's more complicated. They're definitely more complicated than the ITAR. Consequences of noncompliance? Well, as we mentioned earlier, significant teeth, big fines. You can be subject to sanctions and suspended privilege for exports, which for many companies, obviously, if your export privileges are denied, that can be a corporate death sentence. For foreign parties, obviously, if your supply chain is being strangled because your U.S. supplier has been subject to sanctions and has lost his export, that can be a very significant impact for people that are outside of the U.S. And then for those of you that were at the top of the poll there and are familiar, you probably know that face, but that is Professor Roth. Professor Roth was a University Tennessee professor who is now in jail for the next, I think he's got 2 more years of a 4-year sentence, because he was providing information to Iranian students as part of a program that they were working on, and he ended up in jail as a result of that. So again, we go back to them having real teeth. So what's been going on then in terms of export control reform? And the answer is a lot. Export control reform kicked off back in 2009. And then in beginning of 2010, I think it was April of 2010, the report was released that then Secretary of Defense Robert Gates agreed that our system was outdated. Remember that these regulations are really children of the Cold War. These were regulations that came out of the 70s and have seen no real significant revision up until this point. So the realization was that we were trying to control too much, and as a result of trying to control too much, we didn't control any of it very efficiently. So we needed to revise the regulations. The goal, well, there were motivations. First of all, the motivations. One of the biggest issues was that U.S., especially parts and components manufacturers, were suffering as a result of a lot of foreign purchasers refusing to take products that have been subject to ITAR control because the ITAR jurisdiction continued to attach, and that causes all sorts of problems that we'll talk about again in a minute. The other problem was that the government was approving licenses that were very easy to approve. These were license applications that they shouldn't be seeing. they shouldn't be spending so much time approving licenses that were an easy answer. They needed to be looking at the ones that were close call, because that's the technology that they needed to be controlling. We needed better coordination with our allies, and the goal was to end up with basically 4 singularities: a single control list, a single agency, a single enforcement agency, and a single IT platform. Well, we don't have any of that yet, but we've definitely come a long way. And without doubt, the most significant highlight, obviously, and many of you have already heard of, the items that are coming out of the ITAR and are being transferred across to the EAR. Many of these less sensitive items are coming out of the very simple but very restrictive ITAR, and they're moving into the far less restrictive but more complex export control administration regulations. That's obviously a very significant highlight of U.S. export control reform. For those of you that are familiar with the ITAR, you have grown up knowing the definition of anything that was specifically designed, developed, modified, configured, adapted for a military application was considered to be a defense article, unless it had a predominant civil application and had performance equivalents to an article used in a civil application. So that was incredibly broad. If it had been modified, tweaked, changed in any way for a military application, so that it now differed from its civil counterpart, then it was going to be considered a defense article. And as a result of that, a lot of items became ITAR controlled that really probably shouldn't have been. Today, that policy has changed to, if an article is listed, an article is only a defense article if it is listed in the USML, or if it has the same performance equivalent of an item that is on the USML. And then obviously it continues to contain that same catch-all. So what does that mean? Well, this is an example of a Category 8 of the United States munitions list as it existed before October 15th of last year. You can see that you don't need to read all of this, but obviously you have very, very broad catch-all language that controlled all sorts of aircraft, helicopters, very broadly defined. And then most significant, especially for those of you that have clients or those of you that are manufacturers of parts and components and accessories that are going into defense items, aircraft, this was incredibly huge. It was incredibly broad. It covered anything that had been specifically designed or modified for a military application, in this case the military application being a military aircraft. So for example, you had a hydraulic valve that had been specifically manufactured for the Chinook helicopter. Then that valve, even though it's probably very similar to the same hydraulic valve that went into a commercial helicopter, was now controlled under the ITAR and very broad. Well, that's all gone. And the new USML, and again this is the new USML Category 8 as it exists after October 15th, you will see, and again lots of words, but you will see very, very specific positive control criteria. Lists very specific end items, very specific aircraft, very specific systems and items. Gone are the very objective catch-all language with limited exception that you'll see in a minute. But by and large, positive control criteria now under the USML. And if your item doesn't fall within that positive control criteria, it's no longer subject to the ITAR. So the USML has gone from being very broad to being very specific. So if your item is no longer controlled under the USML, for example, now our valve didn't meet any of those criteria in the new USML Category 8, where do they go? Well, they go into this new 600 series under the USML, under the Commerce Control List under the EAR. Now, when we first started talking here in the U.S. about export control reform, I think a lot of people were very excited and a lot of people were hoping that their items, their parts and components were going to become EAR 99. But it really hasn't been the panacea that a lot of people hoped it would be. Your items are still going to be treated as military items by and large. They're still going to be subject to stringent licensing requirements unless they're going to Canada as the one country that doesn't require a license, or if one of the EAR license exceptions applies, or they're in one of these, what's called the Y paragraph, and we'll talk about that, which is basically items that have been decontrolled to the lowest control level, still significant controls, and even to the point where, for those of you that are familiar with the ITAR and are familiar with dealing with prescribed countries such as China under 126, those rules continue to exist under the new 600 series. Just quickly, before we look at the new 600 series, just a quick sort of view of the anatomy of an ECCN there. Anything that's on the Commerce Control List has what's called an Export Control Classification Number, or an ECCN. And then it will be followed by 5 numbers and letters, 1 letter and 4 numbers. The first number would be the category 9 in this instance for aircraft or for aerospace. A is the group. Remember we said earlier there were 5 groups under the Commerce Control List. In this case, A is the systems, equipment, and component. The next one is the reason for control. In this case, it's 6, which is category for the 600 series, which is going to be these items that have moved across from the USML, and also some of the items that were in the EAR already under some of the 018 provisions, which are the Wassenaar arrangement munitions lists, have also moved into the 600 series. And then the last 2 digits track the Wassenaar listing number typically. So here's an example of the new 600 series under the EAR. And again, lots of words. Don't expect you to read the slide in detail. I just want to put it up there to show you the sort of complexity that it has and what it's controlled. You'll see obviously here is the ECCN. We have the reasons for control, significant reasons for control, national security, and RS, which typically means, if you were to look at the country chart, that these items are controlled to most countries except Canada. And you'll see that it includes a broader definition than the ITAR of military aircraft specially designed. We'll talk about that. And then in the remaining paragraphs, the A through W paragraphs, very specific descriptions of the items that are controlled in those A through W paragraphs. And then we have this Y paragraph. And it's always worth looking at the Y paragraph before we look at the X, because these Y paragraph items are the items that have been considered to be so, I don't want to say insignificant, but the least level of control is necessary for these very specific items. So if you're in one of these Y paragraph items, then you're only going to be controlled for what's called an AT reason, an anti-terrorism reason, which means you're only going to be controlled for export to Cuba, Iran, North Korea, Syria, or Sudan, or for nationals of those countries. So always worthwhile looking at the Y paragraph first. And then if you're not in a Y paragraph, then you're going to be in this X paragraph here, which is parts components specially designed for a commodity subject to something that's in the ITAR or the EAR. Again, that's a significant difference. You're going to see a lot of this descriptions both in the ITAR and the EAR now referring to the other regime. As we start to meld these 2 regimes together, you're going to see much more cross-relation between the 2. And in the example of our valve, you'll see that our valve now would fall into this new X paragraph. Other highlights, specially designed is a defined definition that is defined and harmonized between both the ITAR and the EAR. And we'll look at that because obviously that is a significant part of export control reform. There's now the ability to include EAR items on a ITAR license. If you're exporting EAR items that are related to those items that are controlled under the USML, before you would have to have obtained a license under both the ITAR and the EAR. Now you can do that just through an ITAR license, as long as that they're related to that program and to the items that are on that ITAR list, ITAR license. And then for items that have transitioned to the EAR, and we'll talk about this, but it's a significant highlight to the reform, and that is there are significant exceptions under the EAR that are very, very helpful to exporters. And de minimis rules apply, and we'll talk about de minimis in a minute, so I don't want to touch on it too much, but the de minimis is a significant aspect, especially if it results in an item, once it leaves the U.S., losing its U.S. jurisdiction. And obviously, under the new EAR, for items that have come across to the EAR, for those of you that are familiar with having to get TAAs and MLAs for your foreign collaboration with your foreign subs or with your foreign vendors and suppliers, if your item is now under the EAR, there's a significant chance that those TAAs and MLAs are no longer going to be required. That's just an ITAR provision. So what has changed? Well, the first two you see there changed in October of 2013, and that was Category 8, which we've just been talking about. They have now gone across, for the items that are no longer controlled in the new positive controls of Category 8, have now gone across to the 600 series in Category 9, 9A, 610, or if it was software or technology, it would be in 9D or 9E, 610. Also changed at that time gas turbines. Recently, in January of this year, we saw the revisions become final for vessels under Category 6, for vehicles under Category 7, auxiliary military equipment under 13, and submersibles under USML Category 20. And you can see on the right-hand side the corresponding EAR 600 series that those items have gone into if they're no longer controlled under the ITAR. Coming soon to a compliance program near you in July of this year, we've got Categories 4, 5, 9, 10, and 16 coming up. They're all set to become effective. We have final rules in place, and they become effective in July of this year. Still coming up, no final rules yet for Category 11, which is a huge category, obviously, here in the States for military electronics. What we hear is that the final rule is probably going to be released on both Category 11 and on Category 15, which covers satellites, probably in April of this year, with those becoming effective 6 months later. So they're coming fairly soon, Category 11 and 15, and still no rules, even proposed rules yet, for Categories 12, 14, and 18. And they will be the last to be changed. So what are the challenges then as a result of export control reform? The most significant challenge, without a question, is understanding the jurisdiction of your product, the jurisdiction and the classification. And that applies equally to products that are already existing, as well as your products that you have in development. Now we have a much more complicated analysis, arguably. We have to go through this order of review to determine what is the jurisdiction and the classification. And this is being referred to now as the order of review. And you always have to start, just as you always did, you're going to have to start at the USML. Is your item controlled under the ITAR? Is it listed on the USML? Is it specifically enumerated in one of those very positive control provisions? If it isn't, is it caught in one of the catch-all specially designed provisions in the USML? If the answer to both of those is no, then you have to go to the Commerce Control List. And just as the ITAR trumps the EAR, the 600 series trumps the rest of the CCL, the Commerce Control List. So now you have to start your analysis on the 600 series. Is it specifically enumerated in one of those very specific A through W paragraphs? If not, is it in one of those Y paragraphs where it's been decontrolled except to AT, lowest anti-terrorism reasons, or is it in one of the X paragraphs? And again, you're going to have to go through the analysis, is it specially designed? Both you would have to do that under the ITAR to the extent that an item is controlled under the ITAR or the EAR in a clause that uses specially designed. You have to use the specially designed definition to determine whether your item meets that definition or not. And a quick takeaway, obviously, if your item is still on the USML, then your software and related technical data is also going to be on the USML. Otherwise, if your item has moved across to the 600 series and is controlled in Group A, your technology is going to be controlled in Group B and your software in Group D. The only slight confusion to it is if you're dealing with classified technical data, you may have a product that is controlled under the under the EAR, under the Export Administration Regulations, but the technical data, because it's classified, remains under the ITAR. So again, it's becoming more complicated. So that's the first step in your challenge with new export control reform, is going through both your existing and your new products to determine what is the jurisdiction. Your next challenge is understanding specially designed. And specially designed was needed because traditionally, specifically designed was a term used in the ITAR, and it relied on design intent. Whether this item had been, what was the design intent? Was this originally designed for a military application? And that was extremely difficult. You would ask 10 different people, and you'd end up with 10 different answers. So the effort was to go away from design intent to the extent it was possible, and come up with a series of questions that basically allowed 10 people to come up with the same answer as to whether their item was specially designed. And this term obviously is used, specially designed, is used throughout the EAR and the ITAR. And so now it's very important. And we're trying to go away from the design intent that was there previously, especially as determining design intent was often very difficult if, as the slide shows, your engineer was dead and nobody knew what the design intent here was behind the product. Specially designed is complicated. There's no question about it. But it's going to be very helpful to you once you get a handle on it. And both under the ITAR and the EAR, remember these are harmonized definitions to the most part between the ITAR and the EAR. They both operate under this concept of catch and release. Is your item caught by one of these A paragraphs? And if it is, and particularly if it's a part and component, or only if it's a part and component, is it then released? So what you have then is a catch. Paragraph A1 basically is speaking to end items and materials. If something about that end item is the reason that it's being controlled, in other words, it is the chemical that is being controlled under the ITAR, or it is the chemical that's being controlled under the export administration regulations, then you stop at A1, you're caught. Part 2 is a little bit more complicated, and it asks, do you have a part, component, accessory, or attachment that is being used in a controlled item, either under the ITAR if you're using the ITAR definition, or under the EAR if you're using the EAR's definition? And if it is, then you're caught. Well, if we were to just stop there, that would be incredibly broad, and you can imagine that any commercial off-the-shelf, any COTS part or component that was being used in a military application would be caught by that definition because it's being used in or with an item that is controlled under the USML or an item that is controlled on the Commerce Control List. But if you're caught by paragraph A2, you don't stop there. You need to go on and look at these B paragraphs, which are called the release functions. And you have to go through, in the ITAR's case, the 5 release provisions, and in the EAR's case, the 6 release provisions. And again, and we'll summarize these at the end, but lots of words and very complicated. But in essence, paragraph B1 says, do you have a piece of paper? Do you have a CCATS, what's called a CCATS, sorry, a commodity jurisdiction from the Department of State that says that this item is not specially designed? Or do you have a CCATS that says that your item is somewhere on the Commerce Control List in an ECCN that does not use specially designed? If you've got a piece of paper that says that says that you're not specially designed and you're in one of these categories that is not using the language specially designed, then you're golden, you're released. B2, it's pretty clear. If your item is one of these very limited items, if it's one of these fasteners, it's going to be released. This is not an illustrative list, it's an exhaustive list. So if you're not one of those items, you're not released by B2. B3 is what everybody is referring to as the production release. And basically what B3 is saying is, if your item is used in an item that is controlled on the USML, or it's used on an item that is controlled on a Commerce Control List, but it's also used in an item that is uncontrolled, or is used in an item that is controlled only for the lowest AT reasons, and that item is in production, and they have the same function and performance characteristics, and the equivalent form and fit, then it's going to be released. So if it is very similar or identical, or in the best case scenario, obviously the same part is used in both a military aircraft but also in a commercial aircraft, then, and that commercial aircraft is in production, then it's going to be released by B3. Originally the plan was to stop there and not to go any further, but the problem was that for people that have developed a new product, and all of their sales have been initially military, and they don't yet have any sales outside of that, then the challenge was, well, how do we prove that we're being used in a product that's in production? Well, you can't. So that's why we had these remaining B4 through 6 that basically said, if you can prove through with documentation contemporaneous with the development that shows that the design intent was for these items to be used in a dual use or a general use application, if you have documents to prove that, then you can use one of these B4 through 6, but you must have documentation to support that. So that's going to be important to the extent that you're developing products now that you believe, or your clients are developing products that you believe are going to have a military and a dual use application. Developing that document paper trail is going to be very important. So recap, basically, do you have a CCATS or a CJ that says it's not specially designed? Is it a low-level part? Is it used in an uncontrolled and a controlled function? Or if you're relying on design intent, do you have the documents to prove that this was truly designed for both a controlled and an uncontrolled application? Now, I don't want to get too hung up on this, but basically there is a mechanism now in the EAR that if it's a close call and you're not sure whether you were specially designed, you can reach out and get what's called an interagency CCATS, which will be an official determination as to whether you are controlled or not as specially designed. So you've gone through your jurisdiction analysis, you've gone through and you've found your jurisdiction and your classification, you've determined whether or not you're specially designed. The next challenge, obviously, is understanding what are the controls, and if you're ITAR, it's going to be pretty clear-cut. You're going to need a license unless you're dealing with Canada. If you want to get involved in foreign collaboration, you're probably going to need your TAA or an MLA, and you're going to have to be very careful disclosing to foreign persons any technical data, whether that's here in the US or overseas. Alternatively, if your analysis has come up and said that your item is controlled under the EAR now, then you've got to do a further analysis whether you're going to need a license or not, and so on. So a lot more complicated as a result of that. Very quickly, and I'm just going to gloss straight through this slide because of time, some transition considerations. For those of you that is relevant, feel free to look at that slide later on, but you can continue to use your licenses if you already have licenses or existing agreements. That's there for you if you need that. And again, I'm going to move on because of time. The opportunities that this presents, probably the most significant opportunity is the fact that under the EAR, for items that have moved across to the EAR, you have de minimis. If your foreign item is incorporating an item that is now in the 600 series and it's less than 25%, it's not going to be subject to U.S. jurisdiction anymore. It's going to be subject to these de minimis controls. In comparison to under the ITAR, there was no de minimis. You put the smallest ITAR part into your foreign component, it remained subject to the ITAR, and the entire foreign product became ITAR controlled. Note, however, that de minimis does not apply for D5 countries, which are listed at the bottom there. I'm going to quickly talk about STA. Significant benefit of STA, you don't need a license. Rather than obtaining a license, you can obtain authorization through obtaining notifications from the foreign party and prior statements. 36 countries covered under STA. I'm going to gloss through this slide because I've gone over my time. But basically, be aware that for 600 series, the STA is going to only be used for A5 countries, which are the 36 countries, and only if it's being used for a military end use or a government end use, or it's coming back to the United States. And also be aware that the foreign parties, all the parties in fact, have to have been previously vetted through a license application under the BIS or the ITAR. So very important that you remember that. It doesn't have to have been a license that you obtained, but the parties do have to have been previously vetted. Very quickly, last two slides from me. A lot of other license exceptions under the EAR that you can avail. Low value shipments, temporary return, replacement parts, temporary technology and software unrestricted. Lots of export license exceptions there under the EAR that you can make use of. And then finally, next steps, we've touched on this. Review your product matrix, understand the classifications of your products, understand the controls, and then obviously consider the business opportunities that come out of de minimis. For dual use products, obviously start to create the documentation that you need to the extent that you're going to need to prove that in the future. So with that, I went slightly over my time. I'm going to hand it straight over to Kerry, and he's going to take you on into the extraterritorial aspects of U.S. export controls.
Excellent. Thank you very much, Ian. That was great. Very important topic. For everyone, let me just give you a very quick heads up on some of the next steps in export control reform beyond, finishing off addressing all the categories in USML. The ultimate vision is that we're going to have one agency really essentially to go to for licensing, one enforcement agency, and one list. Those are big items. They're going to take some congressional action. They're going to take involve undoubtedly some turf battles. It's going to involve Commerce, State, and DOD needing and having to come together and figuring out a grand vision for those major next steps. But that's just a heads up on us trying to, frankly, harmonize with the rest of the world, at least the rest of the developed world, in terms of export control systems and regimes. Now, I am going to address, here we go, learn as I go here. I'm going to address the oddity of U.S. export controls, the extraterritorial application of U.S. export controls. The U.S., unlike any other nation, exerts its control over its own goods and its own people in a very extraterritorial fashion. Unlike Canada, unlike the UK, unlike even China, we exert control over U.S. origin goods and technologies as if that exist abroad as if they were still in the U.S. In many respects. So in essence, the way to look at this is that a U.S. origin good, a product manufactured in the U.S., obtains U.S. nationality, and control status of that under U.S. law follows the product. Same goes for U.S. persons wherever they may be located around the globe, whoever they may be employed by around the globe. So a U.S. citizen or a U.S. green card holder working for a German company or a Chinese company, that individual's activities need to be viewed through the prism of U.S. export controls. Can make things very interesting for multinational companies and even companies that have otherwise no nexus to the U.S., but they're either receiving U.S. goods or they're employing U.S. persons. On here, the types of activities that get impacted, certainly the activities of the U.S. persons, of the U.S. individuals, wherever they're located, the services they provide, the knowledge that they utilize and convey to others, any engineering-related activities by U.S. persons abroad would certainly be something that should be considered through the U.S. export control prism. The activities of a subsidiary of a U.S. entity absolutely need to be considered carefully, again, from the prospect or the vantage point of U.S. export controls. When we have, say, a German company active in trade with China, or as it used to be and not so much anymore, the Iranians, we had to be very careful in vetting those activities against U.S. export controls, particularly where there's any sort of day-to-day control over the foreign entity by its U.S. parent. Branch offices even more so because they're not even incorporated abroad, so we very much need to be cognizant of U.S. export controls there. Re-exports and retransfers of U.S. origin goods by foreign parties. That's, again, where the nationality of the good, the U.S. nationality of the good attaching at the time it's manufactured in the U.S. Is so important. Let's just take an example. If you have a U.S. origin sensor manufactured in the U.S., exported to Israel for incorporation into a subsystem or system being manufactured, designed and manufactured by the Israelis, the Israelis should be considering the control status of that sensor, whether, again, as Ian put it, it's ITAR or EAR, and discerning whether their retransfer of the system, the retransfer of that article by virtue of transferring the system or subsystem into which it's incorporated might entail requirements for licensure or approval from the U.S. government. It catches non-U.S. parties very much by surprise, this sort of extraterritorial application where they believe that just their own domestic laws should be applying. I'll put one more gloss on that point, and that is that the viewpoint of most countries, really every country other than the U.S., is that they'll control exports by their indigenous persons and companies, and they'll say yes or no that a particular item can go or whether a license might be required. And then and as part of that licensing and review status, they'll be vetting the country to which it's going. So say in the UK, a UK manufactured widget is being exported, they'll either control that on export through a license or not. But once exported, it's free of UK law. And the view of the UK authorities is that, well, we've either approved it or licensed it for export, and now it's up to the country of recipient country to control it under its own laws. Canada's the same, Israel is the same, really every country other than the US is the same. Ian touched on the de minimis rule, so I'll go over this quite quickly. We're wanting to be cognizant of the time here. But here again, where a U.S. origin item is incorporated into a foreign produced item, if it's a EAR controlled item, the foreign party needs to understand what share of the value of the foreign produced item is in fact U.S. export controlled content. Generally the rule is 25% or more could well trigger U.S. export controls over the system into which that item is incorporated, and it's all U.S. origin controlled content that needs to be taken into consideration in that calculation, not just that one item, but all U.S. origin content, again, of a controlled nature. And then a much lesser de minimis level triggers these controls of 10%. There are certain countries that the de minimis rule doesn't even apply to at all in terms of re-exports, and Iran is the chief among them. The Iranian transaction regulations, which were revised substantially last fall, now prohibit the transfer of any item to Iran that's foreign produced to the extent it has within it any U.S. origin content, even uncontrolled content. It's a very, very onerous restriction and something that needs to be closely watched. We helped a company not that long ago that was manufacturing parts for a very significant piece of machinery in Africa for ultimate destination Iran, even though our parts were a rather small and inconsequential part of that system. We were not allowed to fulfill that order to the Africans because of the ultimate destination. And the see-through rule, again, I'll do this very quickly because Ian covered it in large part. We don't even have the de minimis rule under the ITAR. If there is any ITAR component incorporated into a foreign-produced item, that foreign-produced item is now subject to the ITAR in terms of re-export and retransfer by the non-U.S. party. In this realm, we get a lot of pushback from particularly the Europeans. They want very much to produce systems and products that are, quote, ITAR-free. So we spend a fair amount of time navigating those concerns of the Europeans. There are ways, certainly, of obtaining those re-export and retransfer approvals. In many cases, it's actually quite easy. But it is a hurdle that the European parties need to be cognizant of, and frankly, all non-U.S. parties to the extent they're receiving ITAR-controlled parts and components. Thales recently trumpeted having produced an ITAR-free satellite bus. It's turned into quite an interesting battle between Thales now and the State Department over whether, in fact, that Thales bus is, in fact, ITAR-free. There's concern at the State Department that, if nothing else, there's U.S. origin technology embodied in that bus, if not components. And now I'm just going to hit quite quickly, four regimes other than ITAR and EAR. The broker rules under the ITAR, that's where someone is paid a fee or commission in return for helping to arrange the sale or the transfer of a U.S. ITAR item. Certainly U.S. parties are covered by this, but also non-U.S. parties to the extent they're owned or controlled by a U.S. party. And here, to the extent a non-U.S. party is owned or controlled by a U.S. party and is engaged in brokering activity, there's a registration requirement with the State Department, annual reporting, and even requirements to obtain pre-approval for certain activities. Anti-boycott. This can be troublesome, particularly with respect to the unsanctioned Arab League boycott of Israel. We see quite a bit of problematic activity coming out of certain countries that I've listed here. And there is a reporting obligation with respect to any activity that might be anti-boycott related. CFIUS, Committee on Foreign Investments in the U.S., chaired by the Treasury Department and populated by 12 or so federal agencies, including DOD, DOJ, Commerce, State. They are tasked with reviewing transactions involving foreign investment in the U.S. or foreign acquisition of U.S. companies where there may be national security implications. Their reach has really substantially broadened recently. The Smithfield Foods case some of you may have heard about. It's the largest U.S. pork producer, was being acquired by by a Chinese company, and it was reviewed by CFIUS, and there was a lot of concern, in fact, that it would be blocked by CFIUS. It wasn't, but it shows the very broad reach of CFIUS these days. And last but not least, FCPA, and this is very important to foreign parties that are non-U.S. parties that are involved in assisting U.S. companies in obtaining sales, particularly in China and other certain countries where there's a lot of state-owned business enterprise activity, and there's no bribing, no offering of anything of value to a foreign government official for purposes of obtaining or retaining business. And the liability is both on that non-U.S. party as well as the foreign party. I'm sorry, the non-U.S. party as well as the U.S. principal. And Q&A, and I'm afraid we don't have much time, but if we want to get a question or two in, and then as Ian promised, we'll address questions after the fact. as well. Yeah, we don't see questions popping up at this point. Yeah, I don't see questions. I don't know about you.
Nope, it looks like there isn't any questions coming in. We haven't given them much time to type something in. So I think with that, I'll just remind everybody that you can reach out to Carrie and Ian directly if you have any questions after the presentation. I will distribute a copy of the presentation, a recording of the webinar, as well as, like I said, their contact details to each of you via email. You should receive that in about a week. I tend to get it out a little sooner than that, but just in case. I'd also like to just thank everybody. Thank the attendees for being a part, and thank Ian and Carrie, because gosh, that was a lot of information. You did a great job. I think that's it.
Yeah, thank you, Crystal and Meritas, and thank everyone that attended. Sorry we had to move fairly quickly over a lot of content, but we hope the slides are good resources for the future for you, and we are very much open book and happy to answer questions one-on-one at any time. Thank you.
Yeah, great. All right. I hope everybody has a great rest of your day.
Thank you very much. Thanks.
Bye.